Welcome back to the Friday 5 for September 15th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. It's Friday, so we take a quick 5-minute look at 5 questions from the week, usually short questions that maybe have come up in your life too and you're wondering what the answer was. Question number 1 this week. My wife and I own a business together. She gets it when I die, right? This came in the context of meeting with a client who'd set up his business a few years ago with somebody else, and we were reviewing the corporate documents. And for one of the businesses that he and his wife were operating together, he assumed they were joint owners 50-50, and that if something happened to him, she would just get his share of the business. Now, problem number 1 is that's not necessarily the way it happens, and it may actually cause your business to go through your probate court if you don't have the right provisions in your corporate documents. So our next step was to pull out the corporate documents and look at what the operating agreement said. We are a little bit surprised to find out the operating agreement said that that particular LLC was owned 99% by another company and 1% by the client. So his wife wouldn't necessarily get that company when he died. In fact, she may only be entitled to the 1% that he owned personally, because the other 99% was owned by a different business. And if his business interest in that company was being distributed in a different way, then she wouldn't be getting anything more than her share of the 1%, and it still may have to go through a probate court. This shows the importance of having the correct corporate documents for you because, for example, in Minnesota with an LLC, you can do all kinds of planning tactics to make sure that that business can continue and that your family is supported and can receive your LLC interest after you're gone. Question 2 this week. If I change the ownership of my business, do I need to change the ownership of the business bank accounts? The same client was discussing the prospect of moving his businesses into a trust. So he owns a variety of businesses, some with his wife, some with other partners. And what we were discussing was, does it make sense for him to move his business into a trust that he had created a few years ago? And as part of that, the question became, the business accounts are in the name of the business, ABC Corporation or BCD LLC. What do we do with the bank accounts if the company's interest is now held by the trust? And the simple answer is we don't have to do anything because those bank accounts are owned by the business. They are business accounts, and the business owners can be different. And the business owners can be different, they can be changed, and that doesn't affect the ownership on your bank accounts. So think of, for example, Apple and all the different shareholders they have. Whenever there's a new shareholder or a change in ownership, Apple doesn't have to go back to the bank and change around their ownership interest on their checking account or whatever operating account they have. Frankly, Apple probably has its own bank these days anyway. Question 3, how do I decide the value of my business if I want to sell it? So in this context, when you're working with a small business, you're not a publicly traded company, and in this case, it was an individual who owns a business locally who has already found some people who want to buy it from him. And he had a very common question, which is, how do I put a value on this business? So he owns tangibles and intangible assets to his business. Tangible were the things that the company owns, all of the equipment, all of the computers, all of the hardware, all of the stuff that is owned by the company. And then there's the intangibles, his customer lists, his intellectual property, his trademarks, his copyrights. And his question was, how do we put a value on that? And the simple answer is, this is where it's very important to work with your accountant, and if needed, work with a special business valuation professional. There are people out there who value businesses for you. They will come in, look at your books, look at the list of inventory, what you have, what you owe, and from there they can give you an idea of what your business would be worth if you were selling it to somebody. And as I also explained to him, just because the business valuation experts tell you your company's worth $1 million doesn't mean you have to sell it for $1 million. You may want to give a discount to somebody for some reason if they're going to buy the company for you, or you may in fact fetch a lot more than $1 million on the open market. So maybe a variety of bidders come looking at your business and say, this business can be worth a lot more down the road. We'll offer 1.5, 2 million, 3 million, whatever the number is. But that business valuation done by a professional is a great start, so you can have some expectation of what you can get for your business. Question 4 this week, should I create a trust during my divorce proceedings? So the caveat being that I started my career as a family lawyer many years ago, and I've moved on. I don't do contested divorces anymore. In this case, the prospective client is in the middle of what will be a highly contested divorce proceeding. There's going to be a lot of vitriol. There's going to be a lot of fighting. It's not going to be pretty. And he had come up with the idea of, what if I just take my money and move it into a trust? will that mean that the divorce judge won't be able to do anything to that money? So the first place you need to go if you're in this situation is talk to your divorce attorney first. Make sure you understand with them the implications under whatever state you're living in, whatever laws may apply to your divorce. But generally, if a divorce has been started already and you suddenly take all of your money and move it into a trust, that's not going to protect it from the divorce action. And in fact, the judge will probably see right through what you're trying to do and undo the trust and order the money to go back, and you could even be sanctioned for it. Some states have orders that go into effect when a divorce is filed saying that you can't actually transfer any assets pending the divorce. So the courts have seen this for years. People have always tried to find creative ways to get money out of their name to protect it from the divorce, but you need to remember that a divorce court is normally a court of equity, meaning it can do what is right and it can undo those transactions. And question 5 this week, is an annuity a part of my dead spouse's probate estate? So in this case, my client has been appointed the personal representative of her husband's estate, and her husband recently died. Her husband had an annuity with a company that paid out a monthly payment, and the annuity has a beneficiary designation that is not the wife. It is actually payable to his parents. So my client was concerned because the parents continued to get the annuity payments after he died, and she wanted to know why they were not coming to her because she's the personal representative of the estate. She's his wife. She's entitled to inherit under his estate. He did die without a will. But the question is, why wasn't that annuity coming to her as well? And the answer is that when you have an annuity with a beneficiary designation, it passes outside of your probate estate. So that money will go where, in this case, her dead husband had designated it, to his parents. In order for her to be able to transfer those payments over from his parents to her would mean that the parents would have to sign off on a transfer. And you can do that, and you have to go to the company that is managing the annuity in order to be able to do that. However, just because you're the personal representative of the estate doesn't mean you control all of the assets. There are usually going to be assets that are outside of the probate estate, and anything outside the probate estate is not controlled by the personal representative. So that's our 5 questions for this week. If you like this video, you can hit the like or the thumbs up button below. You can subscribe on YouTube for future episodes. You can submit a question for future episodes in the link. And you can always go to andrewmayers.com for a legal strategy session or for some more information. Hope you have a wonderful weekend, and we'll see you back here next week.